May it please the Court, I appear for the defendant. My name is Swaysland, Swaysland. I am instructed by Mr. Falk. Mr. Falk is being restrained by clauses 12, 14 and 15 of his contract with Fossil Fuels R Us. The decision in Nordenfelt v Maxim Nordenfelt Guns and Ammunition Co. Limited, an appeals case from 1984, number 535, states that reasonableness must be in the interest of the parties and also the interest of the public. It also states that all contracts regarding restraints of trade are prima facie void. For the contract to be enforced, the plaintiff needs to prove that Fossil Fuels has a legitimate interest and restraint goes no further than to protect that interest, a principle established in AMCO Australia Proprietary Limited versus Rockabros Motor Engineering Co. Proprietary Limited, a 1973 case found in volume 133 of the Commonwealth Law Reports at page 288. It is of my belief that there is no conclusive evidence which can be rebutted proving that Fossil Fuels is merely protecting its interest. In regard to Clause 12, the principal in Brackus Marsh Concentrated Milk Co. Limited versus Joseph Nathan and Co. Limited, a case from 1919 found in volume 26 of the Commonwealth Law Reports at page 410, stipulates that it is in a company's interest to protect confidential information. However, a rule established in Drake Personal Limited versus Bettison, a 1979 decision from the Victoria Reports, number 13, states that trade secrets and confidential information don't fall under the bracket of the general skills and knowledge a person obtains while employed in a specific position. In the position Mr. Fuchs was in at Fossil Fuels, the defendant would develop numerous skills required to identify key building sites and will build his own general knowledge of oil excavation, making the restriction in Clause 12 unreasonable. With regard to Clause 14, a rule established in Burdanko Nominees Proprietary Limited versus Money, a decision from 2012 in the Victoria Supreme Court of Australia, number 64, is if a person was deliberately using his status within the company at the time to exploit pre-existing relationships, having the intention of using them in the future to establish a client connection, a contract can be enforced. Mr. Falk has not tried to establish a client connection. There is no evidence to suggest that the defendant has had continued relationships with any of the previous clients, nor that he's enticed them to deal with black gold. Additionally, Mr. Falk has not become vis-a-vis the client in his role. Furthermore, given the nature of the business of excavating and digging for oil, there is a limited market for specialists who sell or have digging equipment. It's unreasonable for Fossil Fuels to have a clause preventing an employee from moving to another company from acquiring the same equipment or utilising a mutual supplier. This is reflected in the decision in ICT Proprietary Limited versus Sea Containers Limited, a 1995 case found in volume 39 of the New South Wales Law Reports at page 640. Additionally, the principle found in Infomax International Proprietary Limited versus the Claris Group Limited from 2011 in volume 277 of the Australian Law Reports at page 495 outlines that clients and staff are not obliged to promise an employer or company that they would not be poached by another company. It's not reasonable for Fossil Fuels to demand this of his networks. Clause 15 has no set limitation in terms of area, seemingly reaching a global scale. This seems to be going against the freedom of contractual obligations. Given the wide scope of this restriction, it would seem unreasonable for the defendant to be unable to work for a similar or rival company anywhere in the world for 6 months, as oil excavation is such a niche field. This is reflected in the decision in Butt v. Long, a 1953 case found in volume 88 of the Commonwealth Law Reports at page 476. There are limited oil companies in the world, but given oil has such a high demand, a clause hampering the defendant's eligibility to work in the industry restricts the interests of the public. I put forward that, similarly to the decision in Sea Convenience Stores Proprietary Limited versus Wayville Plaza Retirement Proprietary Limited, a 2012 decision in the South Australia Supreme Court number 14, the needs of oil and fossil fuels for public use need to be readily available. A similar circumstance can be found in the decision from Esso Petroleum Co. Limited versus Harper's Garage Limited, a decision from 1968, appeals case number 269, relating to the need of petrol to be accessed by the public. In addition, the restriction to finding other employment with a company can be restrained by a principle established in Nordenfelt v. Maxim that says consideration should be paid in return for restraint. For the restraint to be reasonable, Fossil Fuels would need to cover over 6 months' salary for Mr. Falk to live comfortably if out of employment. As it is not presented before the court what this generous remuneration actually was, I ask Your Honour to reduce the size of the restraint for Clause 15. Now I turn to relief. Given the unreasonable restrictions in clauses 12, 14 and 15, Your Honour should find that Mr. Fawkes is not in breach of the contract and the contract should be rendered void, allowing the defendant to continue work at Black Gold, and that any legal costs to Mr. Fawkes should be covered by Fossil Fuels.